I will now resume the recording.
Recording in progress.
The court is now resumed.
Thank you. Good afternoon, everyone. We're at the point of hearing. We progressed quite quickly through the first judicial review, the compensation decision. So now we're going to hear from the Attorney General, Mr. Frater, for replying to all of the submissions that have been made on behalf of the respondents and interested parties. So, Mr. Frater, I'll turn it over to you.
Thank you, Justice. Justice, this afternoon I intend to respond to the broad themes and some specific points raised by my various friends in their submissions. Generally, I would say that my friends have avoided some of our main points, tried to recast the tribunal's reasons in a more favorable light, tried to fill in the gaps in the evidence in a way that Vavilov says that you cannot. Since it's freshest in your mind, let me start by dealing with the Commission's submissions that you just heard. I have 6 points to say in response to my friend's submissions. First, with respect to his point about particulars, counsel for the Commission made the argument that particulars are not the end of the story. The tribunal actually said that they were important. The Commission pointed you to sections of the Act that could permit the nature of the claim to be varied. What counsel didn't say to you is that no one asked for amendment or asked for any other change. Second, my friend makes the argument that we should have judicially reviewed the merits decision in 2016 on the basis that they said that there was going to be a compensation hearing. He also makes the point we should have judicially reviewed the 2018 CHRT-4 decision on the basis that it used the word duration in relation to compensation. We don't accept that that was appropriate. We knew there was going to be a compensation hearing. Seeking judicial review at that point to stop the hearing from taking place would have been rejected. My friends would have moved to quash and it would have been granted. We are not, the second point he seems to make about the fairness is that we were on notice from the AFN and the Caring Society that they were asking for this type of relief. And we're not saying that they didn't ask for it. Our position is not that the tribunal invented the relief they gave without hearing submissions on it. We certainly knew that they were going to make submissions in a way that departed from what the nature of the claim had suggested. That isn't our claim about fairness. Our claim about fairness is a narrow one about on such a fundamentally important point about the possibility that the orders would be open-ended. We were certainly entitled to notice of that because that is fundamentally different than the way hearings are usually conducted, and that's a remedy that is highly unusual, bold, to use the Commission Counsel's wording. The third point, in relation to my friend's submissions about estates, let me be clear. We did not seek judicial review of the estates decision, period. The only simple point we made was about the casual way in which the tribunal tried to distinguish Supreme Court case law. Fourth, my friend made the contention that our preferred approach on standard of review is tantamount to correctness standards. With respect, that's not fair and it's not true. We are saying it is not reasonable to rely on broad generalizations. That comes from paragraph 104 of Vavilov. We are saying that a tribunal or other decision maker must justify its decision. Comes from paragraph 86 of Vavilov. We are saying that both reasons and outcomes must be reasonable. That comes from paragraph 86 of Vavilov 2. Those are not attorney general preferences. That is black letter law that is essential to your consideration of this case. Fifth, my friend talked at some length about the cases of Mangani and CNR, which we've referred to in our factum. I didn't deal with it in submissions because in oral submissions, you don't deal with every single point in your factum. But to respond to what he said, we have the Mangani case at tab 21. It's cited by us in respect of caregiver awards. The point, and we've set this out for you, the relevant passages from Mangani, which is binding on the tribunal, and makes a point about statutory interpretation of the Canadian Human Rights Act. It sets out an important interpretive principle. My friend's response to that binding case law is to try and say that it's obiter. The tribunal itself, in dealing with a case that we say is binding upon them, makes no reasonable attempt to distinguish it. It's dealt with in a throwaway sentence, which you'll also find at tab 21. With respect to the CNR case, which we've also given you at tab 19, we made a very small point about the Federal Court of Appeals decision about who is a victim in a human rights case. That point was not appealed. Again, the Commission says that binding case law is obiter. And in our respectful submission, the Commission and the tribunal itself have an odd way of dealing with binding case law. The sixth point, my friend's final point, the so-called dialogic approach. We don't disagree that some back and forth can be useful and valuable. It occurred in this very case in that we filed a judicial review at one point and were able to avoid proceeding with that judicial review by negotiating with the parties and the tribunal changed some of the language of its reasons, and we abandoned the judicial review. If you want to call that dialogic, it worked in that circumstance. And it may be appropriate in other cases cited by the Commission. But here we say it is not an appropriate approach where the tribunal makes broad orders on compensation, then effectively tells the parties to go away and figure out who should get the compensation. In our submission, that turns the ordinary procedure in litigation on its head. Those are the points I want to make in relation to the Commission. Now, with respect to my various other friends, if you're keeping score, Justice, I have 16 points to make about their submissions. And they're all relatively brief, as were my points about the Commission's submissions. My first point is that assertion is not evidence. Our contention in this case is that the tribunal simply asserted repeatedly that the evidence was considerable. In defending that argument, the Caring Society reinforced our point by reading you paragraphs that assert rather than demonstrate or justify. For example, paragraphs 161, 164, and 155. Vavilov says a decision has to be justified. It is not enough to say, as the tribunal says, effectively says, we heard lots of evidence. It is not enough to say, as my friends, several of my friends pointed out, pointing to the number of days of hearing and the volumes of paper filed to assert that there was lots of evidence. We do not dispute that there was lots of evidence. Our contention is that it was aimed at showing that the funding system was broken and had to be fixed. It is being fixed. My second point relates to misstatements of the bases of the tribunal decision. First, the tribunal in our submission did not hold that the act of removal is the harm. It simply does not say that in its relevant orders, starting at paragraph 245. Second, it is true that the tribunal can award damages for loss of dignity, but that was not the basis for the orders in respect of removed children. Dignity was only mentioned lightly in paragraphs 166 and 167, which, as I told you on Monday, are deeply problematic paragraphs. Paragraph 166 mentions dignity, does mention dignity, but it misrepresents the Supreme Court's decision in Godbout, which was not about child removal at all and did not reference it. Paragraph 167 did mention it in respect of parents and in relation to the impact on psychological integrity, psychological harm, and distress caused. Notably, these are consequences of the discrimination, which can vary and need to be assessed, not dignity or the fact of not being free from discrimination, as the parties assert the tribunal compensated for. Now, in fairness to the tribunal, dignity is mentioned in relation to Jordan's principal compensation, but the tribunal has a much more fundamental problem in relation to that award, such as the fact that it was not part of the complaint, and it is based on a definition that did not crystallize until 2017. Justice, if you look at any of the decisions of the tribunal mentioned before 2019, as we have, you will not find a single reference to dignity interests. So while my friends accuse us of trying to redo the facts of the previous decisions, on this point, we say it is them who are trying to recast the tribunal's concerns. Third, what you did not hear from my friends. What you did not hear from my friends is a credible response to our contentions about the shifting nature of their complaint. There was no attempt to defend it as it was framed, as a basis for compensation. Instead, my friend from the Caring Society made 4 points. Her first point was that the complaint was drafted in 2009, so the dollar amount is now greater. And we certainly accept that there may have been some inflation, but the exponential increase and payments directly to individuals is not explained by anything other than a fundamental shift in what was originally asked for. Second, with respect to willful and reckless damages, counsel for the Caring Society stated that the reason for not asking for this was that they did not have the documents. With respect, that simply is not true. They had the Wenday reports. They had the Auditor General reports. They had the National Policy Review. They believed, when they filed their claim, that they felt they could demonstrate that the system was broken. and that Canada knew it because Canada had equal access to those documents. The claim of lacking the necessary information is not sustainable. Nor did you hear from my friends that any case law supports the willful and reckless award. Now, if you look at paragraphs 130 to 132 of our factum, we have provided cases that we say do not support the willful and reckless award here. The primary among them is the decision of your former colleague, Justice Mondaman, who says that that to qualify as willful and reckless, it must be wanton and heedless. What my friends rely on are internal documents from the government that shows the government knew there was a problem. In our respectful submission, knowing that there is a problem is a long step away from saying that because you didn't take sufficient steps to cure the problem right away, you are wanton and heedless. That is not a fair characterization of what occurred in this case. The third point my friend made was that the tribunal can choose remedies for itself regardless of what counsel suggests. To that, we say, not in any fairly conducted litigation, not when the award is the sweeping award that was made in this case. Fourth, my friend said that Canada always knew compensation was sought. True. But we also put them on notice in our particulars that we did not think that they could get compensation on the claim as framed. So they knew they needed to build a record to support it and failed to do so. Now, the AFN take on this point is that we are arguing that the claim for compensation took us by surprise. That is not at all true. I read to you on Monday the relevant paragraphs from their particulars, where they did ask for some indirect compensation for removed children. None for Jordan's principal, none for parents and caregivers. And I hasten to add that what they did ask, what they did suggest in relation to Jordan's principal in the complaint, and I'm not going to take you to it, but it's important that you have another look at it, that Jordan's principal was a cost-neutral solution to ensuring child's needs are met. That the distance between that claim and handing out large amounts of compensation, individual compensation for Jordan's principal is a massive distance. So in my respectful submission, I read as well to you from the particulars, they didn't make out anything approaching what was awarded. My friends, with respect, have not answered any of these points because they know that the way they framed the complaint does not justify the orders that were made. Indeed, counsel for the Caring Society tried to reframe the nature of the complaint at the beginning of her submissions. Now, I hope my notes are accurate here, but here is what I believe she said the complaint was about. She said that it was about two things. One, the right to access and receive equitable and culturally relevant child and family services, services that are aimed at supporting families so that children can remain safely at home. Two, the right to access and receive without delay equitable social services, services that support and promote the child's right to equity and substantive equality. With respect, that is an ex post facto recasting of the complaint that attempts to line it up with the compensation order. The second point in particular is an attempt to justify the Jordan's Principle Award using language inconsistent with their complaint. As I said to you on Monday, a complaint and particulars have to mean something. It cannot be a moving target and cannot be completely reimagined at this late stage of the proceedings. It was and is a claim about inequitable funding. Fourth, defending the reasonableness of the compensation award by comparing it to another decision of the same panel in the same litigation is an extraordinary attempt at bootstrapping in our submission. There is no logic in defending one decision of a tribunal by pointing to another decision of the same panel as if the other operates as a baseline for reasonableness. What you needed to hear from my friends with respect is whether there is some other case that justifies this order. You have not heard reference to precedents that would justify it. My fifth point is that the actuals decision from 2018 must mean something. Our point about the 2018 actuals decision was based on the following propositions, Justice. First, that this is a case about discriminatory underfunding. Second, that Canada had spent billions to remedy the underfunding, which the tribunal knew. Third, in 2018, the tribunal ordered payment of actual costs of delivering services. Yet, in September of 2019, the tribunal ruled that the discriminatory underfunding is ongoing, such that every child and parent gets compensated up to today and beyond. Yesterday, Counsel for the Caring Society attempted to justify the alleged ongoing discrimination by referring to events taking place between 2016 and 2018. My friends have not answered our point that the awarding of actuals and the investment of billions to respond to tribunal decisions after 2018 is a sea change of circumstances that is not reflected in any way in this decision. The effect of this decision is that Canada's underfunding of child welfare is, according to this decision, as discriminatory today as before we took any action to respond to tribunal decisions. That is, in our submission, illogical and unreasonable. My sixth point is a critical point about the Caring Society's position on how Canada could bring the discrimination to an end. Now, Counsel suggested to you that what Canada could do is go back to the tribunal and lead evidence that unnecessary removals had stopped. Now, let's think about that for a moment. What would Canada have to do exactly to meet that onus? Show that it had made sufficient investments, that the rates of removal had declined? Over what period? And could we prove the relationship between the investments made and the results? The research that the tribunal relied on only ever argued that investments would be likely to produce better results. The Caring Society, with respect, is proposing something that is a prescription for proceedings without end, because on any understanding, it will surely take time to decide which investments in prevention will produce the best impacts in which communities? Would we examine the results locally, regionally, or nationally? The suggestion my friend made is, with respect, unreasonable. And I stress this point because it is connected to the tribunal's use of the term unnecessary in relation to removals. You will recall that on Monday, I spent much time going through the tribunal's order on unnecessary removals in paragraph 245 and how it failed to reflect the research on which it is based or account in any way for the role played for provincial or First Nations agencies in carrying out provincial law and in deciding where the child should be placed. None of my friends tried to defend the statements made in paragraph 245 of the compensation decision or the use of the term unnecessary to describe removals made for a child's safety. Seventh, the justification for compensation for parents and caregivers. Justice, you've asked several questions about the justification for this part of the compensation decision. And in my respectful submission, none of my friends have provided a satisfactory response. No one, for instance, has explained how we went from a complaint in which indirect compensation was requested for removed children to a decision that could give as much as 2/3 of the enormous sums at issue to people who were not part of the claim and not part of the evidence. And there was certainly no obstacle to hearing from at least some of them. In answer to a question from you, Justice, about the Caring Society position on the evidence to support compensation to parents and grandparents, my friend said that the issue is intuitive. With respect, intuition is not evidence. Presuming facts is not evidence. Vavilov says that decisions must be justified. Intuition, with respect, does not suffice. Now, the AFN pointed to two paragraphs from the decision, paragraphs 166 and 167, and attempted to use a proposition of law from a Supreme Court case to fill the factual vacuum. This is not a situation where judicial notice applies. There was no obstacle to calling evidence. They simply failed to do so. That failure is, if anything, more serious on the Jordan's principal side, where the range of supports and services at issue are vast. $40,000 to each parent for unreasonable delays. Now, let's take a look briefly at the chart of services provided under Jordan's principle. It's at the very end of tab 16 of volume 1 of our condensed book. Now, counsel for the, I'm going to leave this with you, but I want you to have it in mind, because counsel for the AFN gave you an example of a potentially serious case where delay could cause parental anguish. But so, I urge you to have a look at this.
Just before you finish this point or continue, you're saying tab 16?
Yes. Okay. Sorry. I should have waited till you get it up. It's Exhibit A.
I have the right
affidavit.
Exhibit A.
Exhibit A to the affidavit of Valerie Gideon.
Okay.
Yes. So there's a list of categories there that give you a good sense, in my submission, of the range of supports and services that children can get under Jordan's principle. And my point is that the list is so diverse, it cries out for differentiation of experience to be recognized in any just damage award, assuming as is our position, assuming it is even legitimate to award compensation, in this case, as framed by the complainants. If they can get over that initial hurdle, which we say should be insurmountable, they cannot justify the failure of the tribunal to differentiate experiences in this decision. Now, my 8th point relates to causality and proportionality. As I understood them, my friends sought to deny that principles of causality and proportionality are relevant. Counsel sought to dismiss our position as being about a mathematical exercise. With respect, that is not a fair characterization of our position. What we are doing in my submission is demanding adherence to principle and precedent as a baseline for reasonableness. What they attempted to do is dismiss causality as being some sort of tort law principle that has no application to the circumstances of this case. Now, at tab 12, and I've already taken you to this once, we gave you, sorry, when I say tab 12, I'm talking about tab 12 of volume 1 of our condensed book. At tab 12, we gave you 3 cases, 2 of which are human rights cases, 1 from this court and 1 from the Court of Appeal, that says in human rights cases, causality does matter. Those cases were binding on this tribunal and they can't be ignored. Now, quite beyond those cases, my friends provide no case that show that the particulars of a victim's experience does not matter. Experiences must be differentiated. Walden, mentioned several times in these proceedings, does not support the broad brush approach taken by the tribunal and my friends, nor does Netrium Networks, which I read to you on Monday. What the tribunal does is at paragraph 127, and several of my friends have relied on the same passage from the Jane Doe case. So I think it's important to go to Jane Doe to see what was actually decided there. We have given you the relevant excerpts at tab 5 of volume 1, and I want you to turn that up because it's been mentioned so many times. I think it's important that you have a look at what the court actually said. Now, what the tribunal relied on here is the statement at paragraph 29. So if you have a look at paragraph 29, you'll see what both the tribunal and my friends are relying on. And what they rely on is the statement at paragraph 29 that when you use the case for the, they use the case for the proposition that where pain and suffering is proven, compensation follows. But the statement in our respectful submission is qualified by the important phrase, where the evidence establishes pain and suffering. It also presumes that it was a case where the complaint was framed as one of individual compensation. But my main point about Jane Doe is that my friends and the tribunal stopped reading the decision too soon. Because if you go to paragraph 33, immediately after the one on which they rely, here's what the Jane Doe court said. The evidentiary record before the board required the board to consider a number of questions. At a minimum, the board was required to, 1, review the evidentiary record and find, as a matter of fact, the extent that pre-existing conditions or domestic stress caused or exacerbated the applicant's many medical and psychological symptoms and conditions. 2, determine what symptoms or conditions were compensable as harm arising as a result of a discriminatory practice in light of its finding findings of fact. And 3, consider whether all of the harm could be attributed directly to the discriminatory practice. Now, on that list, the third one is critical to our case. The decision maker has to consider whether all of the harm could be attributed directly to the discriminatory practice. And sorry, there's one more point I want to make about this. I apologize, Justice. Yeah. Sorry, in addition to the Jane Doe, which is crystal clear in our submission, I want to take you to the LeBeau case, decision of Justice Locke of this court, as he then was. He's now in the Court of Appeal, as I understand it. It's a case that's cited at paragraph 87 of our factum, and it's also cited, I believe, in the Caring Society's factum. But let me read paragraph 31 of LeBeau to you. In my opinion, the reasoning of Justice Zinn regarding the absence of evidence of medical treatment and the extent and duration of the harm can be applied to this case as was done by the adjudicator. The purpose of section 53 sub 2 of the CHRA is not to penalize the person who committed the discriminatory practice, but to eliminate as much as possible the impact of the discrimination on the complaint. Thus, an adjudicator must be able to determine the extent and seriousness of the alleged harm in order to assess the compensation that should be awarded. In our case, that means whether all of the harm could be attributed to the systemic underfunding and to what extent. Did my friends point you to where in the tribunal's decision they conducted that analysis? We say they did not. And that lack of reasoning is reflected in an order in paragraph 245 that rests on broad generalizations and misstated evidence. Vavilov, with respect, says that is not good enough. This reasoning is inadequate. It fails to justify, and the outcome becomes unreasonable. My friends from the AFN also brought to your attention the case of Campbell. Campbell, if you read it, does not help them at all. It is a case where there was clear evidence from several witnesses that spoke directly to the issues on compensation. That is not our case. My ninth point relates to the alleged collateral attack on prior judgments. This is a point that was made repeatedly by my friends and is not a strong one in our submission. Ironically, we are criticized as heartless and callous for bringing these judicial reviews, and now criticized just as vociferously for not reviewing the prior decisions. Far from collaterally attacking them, we spent billions implementing them. As shown in paragraph 44 of our factum, we did not review decisions that provided systemic remedies to a systemic complaint. When the tribunal pivoted, we came to this court with narrow applications challenging specific decisions. We are not collaterally attacking the fact finding in those decisions. We say that the tribunal could use the facts in those decisions that they had before them to make the orders that they did in those decisions. But you can't turn around and use the evidence filed for one purpose for another. My 10th point relates to the evidence of Marie Wilson, which is relied on by several of my friends. And it follows from the previous point. Now, Marie Wilson is an eminent Canadian who provided an affidavit in support of a non-compliance motion filed after the merits decision. She spoke of the evidence she heard while serving as a commissioner of the TRC. Counsel as well for both of the main parties also spoke to you about residential schools, 60 Scoop, and day scholars as being part of the context of this case. Now, we do not dispute Canada's shameful history of treatment of First Nations people. We accept responsibility and are committed to addressing a deeply flawed child welfare system. That work is well underway, as this decision fails to acknowledge. But what we have been trying to argue to you is that all cases have a jurisprudential context that serves to structure the proceedings. And this was a case about discriminatory underfunding and how to fix it. The context of Ms. Wilson's experience and the context to which counsel referred are certainly relevant to the issue of whether systemic problems exist and how to fix them. Now, let me give you a concrete example to illustrate what I mean. When the tribunal added the principle of substantive equality to the definition of Jordan's principle in 2017, it was justifiable because the context of residential schools and the effect of intergenerational trauma means that many First Nations kids, particularly those on reserve, may have more complex needs than other Canadian children. They need supports and services that reflect those needs. So the context my friend refers to helped inform necessary change. I would say the same of the example that counsel for Nan gave you this morning. It is a terrible situation, but the context in which that evidence was provided to the tribunal matters here. It was given in relation to a request to get a systemic order to do a study on health services, and it was granted. Where we draw the line is in saying that the same context justifies the awards of individual compensation made in this case. It does not. And you can see that the tribunal improperly used that context in paragraphs such as paragraph 155, which I took you to on Monday. A decision maker cannot just bolus, import the reports of other bodies to decide issues of individual compensation for discrimination. My friends have given you no authority that supports that proposition. This is another example of what I would submit meets my friend from the Commission's characterization as a bold step. It's a bold step because there is no case law to support it. The fact that the Canadian Human Rights Act gives the tribunal flexibility in receiving evidence does not permit the tribunal to ignore basic legal principles or put that evidence to other uses. My 11th point relates to systemic reform and individual compensation. Now, Justice, I spent a lot of time on Monday trying to carefully walk you through our position on systemic complaints, as well as the Supreme Court decision in Moore and how the tribunal had misunderstood our position, only to have my friends attempt to perpetuate that misunderstanding in their submissions. Let me say once again, we do not view systemic remedies and individual remedies as mutually exclusive or binary, in the words of counsel for the AFN, or a dichotomy as submitted by the Commission this morning. Both types of remedy can be given in a case, as long as it is consistent with the complaint as framed by the complainant and supported by the evidence. That is the proposition that we take from Moore. Now, the AFN in their submissions claims that paragraph 63 of our factum is at odds with this position. Let me read that paragraph to you. Not sure whether you have ready access to it, but if I give you a minute, perhaps you can call it up.
Yes, I do have it in front of me.
Well, I would like to read the whole thing to you. In Moore, the BC Human Rights Tribunal allowed the complainant to lead evidence of systemic discrimination in a complaint by an individual seeking compensation for denial of access to education due to their dyslexia. However, when the BC Tribunal relied on that evidence to award systemic remedies, Supreme Court concluded that the systemic remedies were too far removed from the complaint as framed by the complainant. The Supreme Court upheld the individual remedies, but set aside all of the systemic orders because they did not flow from the claim. In the words of the court, while systemic evidence can be instrumental in establishing a human rights complaint, the evidence of systemic discrimination was too remote to demonstrate discrimination against Mr. Moore individually. The same principle applies with equal force here. Having pursued a complaint of systemic discrimination, the complainants received the remedies they sought, changes to the policies and practices that caused the underfunding. They were not entitled to a sweeping compensation order to individuals they did not represent and whose circumstances were not in evidence, so could not be properly reflected in any tribunal compensation order. We stand by that paragraph as a proper statement of our position and a proper understanding of the Supreme Court's decision in Moore. The Caring Society referred in their factum to the Hughes and Hogan cases as cases where the tribunal awarded both systemic and individual remedies. Both cases, however, involve complaints brought by individuals where their specific circumstances and the effect of the discrimination were in evidence. In Hogan, all the people who fell within a certain situation were compensated, but that totaled 3 people, all of whom were complainants who gave evidence. My 12th point is the definition, relates to the definitions decision. Counsel for the Caring Society tried to defend the rationality of the definitions decision, but did not fairly describe either the decision or our position on it. Counsel attempted to portray the decision as a measured one, where in reality, in our submission, it is far from that. Counsel took you to paragraph 117, and let's go back there. You'll find that in volume 2 of our book. Tab 2. Now, what counsel pointed out to you in paragraph 117, if you have it there, Justice, is that the tribunal accepted Canada's position that a service to be compensable should have been recommended by a professional. And that is a fair statement of what happens at sentence 1 of paragraph 117. But with respect, what the tribunal gave in the first paragraph, it took away in the last. If you look at the last sentence, what it says is that the absence of proof of assessment, referral, or recommendation should not automatically disentitle a claimant. This flexibility should also be reflected in the parameters of the compensation process, and it is in the compensation framework. What you have in respect, in our respectful submission, is not a rule, but a flexible statement such that you end up with a situation where the exception swallows the rule. Again, the result is that compensation can be paid after this definitions decision where there was no request, no recommendation, no real harm, no dispute between governments, no delay that exceeds delays commonly experienced by other Canadians. And with respect, Counsel for the Caring Society mischaracterized our position as being that we were saying First Nations children were trying to get services faster than others. That is not our position, not at all. We say First Nations kids may be facing discrimination where they wait longer than other kids. 13, on procedural fairness. Now, counsel for several parties repeatedly pointed out things such as that the tribunal frequently reviewed our arguments before rejecting them. We're not here to argue that the tribunal was unfair to us at every turn. What we are saying about procedural fairness is essentially two things. Don't change the nature of the case on the remedy hearing. And if you are going to decide an issue as important as that compensation to remove children is going to be open-ended, you should at least give us the chance to persuade you that you should not do that. Those are modest demands for procedural fairness that were not observed here. My 14th point is on the evolution of Jordan's principle. Now, the justification for the Jordan's Principle Award is ostensibly Canada's failure to implement what is called in the merits decision the full meaning and scope of Jordan's Principle. But at the time that order was made in 2016, the only definition of Jordan's Principle we had was that of the House of Commons, which was short on detail, except that it referred to jurisdictional squabbling. The complaint focused on the jurisdictional dispute understanding of Jordan's Principle. The tribunal's definition, including the critical reference to the principle of substantive equality, did not emerge fully fleshed out until 2017. So this phrase, the full meaning and scope of Jordan's Principle, was in no way defined by the tribunal in its merits decision. Before that, it was simply a non-binding resolution of the House of Commons. Justice, at one point, you referred to Jordan's Principle as a program. It is not a program. Counsel for the Caring Society referred to it as a legal obligation. And she is right in the sense that Canada is obliged to carry out the orders of the tribunal. But the evidence that Jordan's Principle has evolved under the direction of this panel is undeniable. And because it evolves, there can be no just compensation for reaching back in time to assess it. Now, Justice, excuse me, I've lost one page of my note here. Yeah, okay, sorry, you can't award compensation on a standard that had yet to emerge, is simply my point. That too is fundamentally contrary to our principles of justice. My 15th point, what is compensation ordered for? My friends have insisted to you that compensation is paid for the act of removal and the offense to dignity. Curiously, none of the orders they are defending say that they're based on that. Although, as I said before, the reasons on Jordan's principle, dignity is mentioned in passing. On removal, my friends are much clearer than the tribunal is. And we have tried to collect the relevant passages for you at tab 18 to show you what you mean, what we mean. I'm not going to take you to them. Now, my final point relates to the absence of evidence. And I say again, hopefully for the last time, that we do not demand that young children be called as witnesses. What should have happened in this case is that there should have been clear statements in the complaint and/or the particulars that compensation should be paid directly to individuals removed, to their parents and caregivers for failure to observe some knowable version of Jordan's principle, and for the parents and caregivers of those children too. That should have been followed by a hearing where evidence was called to support it, directly or indirectly, by agreed statement of facts or broad categories. In other words, Justice, what we are asking for is something that looked like every other case before the tribunal in which individual compensation had been ordered. My friends all seek refuge in the idea that young children should not be re-traumatized. As I told you Monday, we wholeheartedly agree. And in drafting the compensation framework, collaboratively with the parties, we looked for ways to avoid just that result. We had a meeting of minds with the AFN and the Caring Society on that very point. But Justice, it is simply untrue that no evidence could have been called. Justice, you have the advantage, you had the advantage of sitting on the stay motion in this case, where the AFN filed affidavits from 2 university students who are potential recipients of compensation. Does the AFN now say that such evidence is impossible to put before the court safely? My friends, with respect, are refusing to admit what they know to be true. It is entirely possible, even in the delicate circumstances of this case, to produce evidence. They did not, and the tribunal simply said they knew what the evidence was. Now, in summary, Justice, Canada is prepared to pay fair and equitable compensation. The compensation framework will help ensure payments are made in a sensitive way. And when that day comes, which all of us hope is going to be soon, that can happen. But this decision is not the path to payment. That path, with respect, lies through this court in a class action. The provisions of the Federal Courts Act dealing with applications for judicial review perform an essential service in our administration of justice. They ensure that tribunals and other statutory decision makers make reasonable decisions, and that they stay in their lane, as one of my friends said. Supreme Court's decision in Vavilov demands that you conduct a robust review. The judgment has to be reasonable in its reasoning and in its outcome. With respect, the tribunal's compensation decision fails to meet reasonableness standards, and we ask that you set it aside. Subject to any questions, Justice, those are my submissions in reply.
No, Mr. Prater, you've answered or responded to the question or to the issues raised by your friends and clarified some points that I had made or alluded to. So I don't have any more at this point. So thank you for your submissions.
Thank you, Justice.
So as we had indicated before lunch break, I think Mr. Frater and would like to begin the submissions tomorrow on the judicial review on the First Nation child definition. So this part concludes the definition, the judicial review of the matter T-1629-19, the compensation decision. So we will adjourn for today and reconvene tomorrow morning at 9:30.
This is well noted. Thank you, Council. Thank you, Justice Fable. The court is now for recess for tomorrow morning at 9:30. Thank you.
Thank you.
Recording stopped.